Hi, welcome everyone to today's virtual roundtable on Asian law, which focuses on a book by Professor Donald Horowitz on constitutional processes and democratic commitment. We are very pleased to be able to have our esteemed panel here with us today to share their thoughts about the book as well as some themes that arise from the book itself. My name is Jaclyn. I'm the director of the Center for Asian Legal Studies. And this virtual roundtable is part of a series that we put together in the wake of COVID-19 in 2020. And it serves as a platform for the discussion of developments in law in Asia and for the exchange of ideas concerning these developments and where these developments should go. In today's session, we have with us three speakers: Assistant Professor Dian Shah, Dr. Shamshad Pasarlay, as well as Professor Rosalind Dixon, in addition to, of course, our author here, Professor Donald Horowitz. I'll be very brief in introducing them because we've already provided you with their longer bio. Let me start with Professor Don Horowitz. Professor Don Horowitz is, of course, well known to all of us who work on constitution making, as well as in particular in areas concerning divided societies. He is currently a professor of law and political science emeritus at Duke University and is the author of various books, including the one I suppose I've worked quite, including a Democratic South Africa, Constitutional Engineering in Divided Society, which won the Ralph Buncher Prize of the American Political Science Association. He is, of course, a longtime friend of NUS Law and the Center for Asian Legal Studies. We're very happy that we've been able to host him several times here in Singapore, and hopefully that with borders reopening, we will be able to see him in person in Singapore again soon. We will then move on to Dr. Dian Shah, who is my colleague here at the National University of Singapore and Faculty of Law, and a close associate of the Center for Asian Legal Studies. Among others, she is the author of a book on constitutions, religion, and politics in Asia, and currently sits as a member of the Malaysian Consultative Council on Foreign Policy under the Ministry of Foreign Affairs in Malaysia. Next, we have with us another dear friend, Dr. Shamshad Pasarlay, who is currently a visiting lecturer at the University of Chicago Law School. He was previously a lecturer at Herat University School of Law and Political Science in Afghanistan, and again has also visited us twice, here once. And we look forward to being able to host him again. And last but not least at all, Professor Rosalind Dixon is currently Professor of Law and the Director of the Gilbert and Tobin Center of Law at the University of New South Wales, Sydney. She was also the past co-president of the International Society of Public Law, and again, one of a close friend of the Center for Asian Legal Studies, and we hope we'll again be able to host her in person sometime very soon. So today's proceedings will proceed as such. We will first have John share a few thoughts on his book, Constitutional Processes and Democratic Commitment. Then we will have Dian share her thoughts, and then going on to Shamshad and to Ross before Don will have an opportunity to respond. Now, if you have any questions, please feel free to type your questions in the Q&A function at the bottom of the screen. Should you sort of wish to speak, if you have a question that you think is perhaps too involved and you would like to speak, please just type into a Q&A as well and request. We will try to give you some time for the oral questions as well. So without further ado, how should we draft a constitution to maximize or optimize its potential for democratic commitments? Well, Don, take it away.
Oh, thank you very much, Jaclyn, and thanks to all the participants for being so brave as to read, through this. Sorry about that. It's allergy season here. I should warn you in advance. There may be more episodes of this kind. We've had a very rainy and a very sunny spring, and which is an unfortunate combination. I'm going to say something about what this book is about, why I wrote it, and then I'm going to say some things about its main themes. I begin by saying we don't know very much about the best prescription for constitutional processes. We know one thing pretty much for sure, and that is that inclusion through democratic elections, inclusion of all relevant social and ethnic groups is associated, that is correlated with democratic outcomes. Beyond that, we don't know very much at all, and it's one reason, by the way, I think why so many people say, oh, well, we know about public participation. More about that at the end of this little talk, if I have time. In any case, somebody's going to bring it up for sure. I've studied or been involved in several constitutional processes over the years, and I've seen a lot of failures. One of the common denominators of failure in places like Iraq, to some degree in Kenya, definitely in Fiji, and also to some considerable degree in Nepal, is private deal making. In Nepal, actually, they took a vote, but the vote was the result of a private deal. In the other three cases, there were private deals to include some people and exclude other people, and they resulted in a high degree of failure of the process to achieve its objectives. I followed the Indonesian constitutional process closely, partly because I had a serendipitous invitation at the outset of the process to visit Indonesia, and that resulted in more invitations, and then it finally resulted in a full-length book project, which produced that book that Jaclyn referred to, Constitutional, what is it called actually? Constitutional Change and Democracy in Indonesia. Here it is, there. It's still available, still in print.
Books, you can forget their names.
It's still in print and can be purchased. Having followed the Indonesian process very closely and having written about it, I began to think that maybe there's something more generalizable in that process. The Indonesians worked completely by consensus. They took only one quite insignificant vote in the 3 years in which they worked on this constitution. And I began, this might have had some major effects on the outcome. That is the consensus part of it. And then I looked at some other cases of constitutions that had been made by consensus, notably India and Tunisia. And both of them seemed to me to have a pretty high degree of democratic commitment on the part of those who participated in the constituent assemblies. It's true that Tunisia has had a coup following the conclusion of its process. But I want to point out that the coup was not made by anybody who was involved in the process, interestingly enough. The president was somebody who came out of nowhere to be elected and then has become an authoritarian along the way. So we know that inclusion is a given. And then I began to think that what we really want is deliberation and argumentation so that people could convince each other of the rightness of their proposals, and they might agree on the rightness of their proposals. This I want to differentiate from negotiation, where one is involved in bargaining and exchange, either for commensurables or incommensurables, and where they only agree essentially to disagree and take half a loaf, as the expression goes. It's also different from voting, of course, where there are winners and losers. In consensus-driven processes, there ought to be very few winners and losers. And by the way, by consensus, I don't mean actual literal unanimity. I have a number of devices which I've spelled out in the book that might eliminate that possibility. So what are the advantages of proceeding by consensus rather than by negotiation or voting? Well, deliberative democracy studies and also jury studies in the United States, where unanimity is required for a criminal jury to convict, have the following results. They note that you get more public regarding arguments. They note also that there's more careful listening by the participants of what other participants are saying. And listening, by the way, takes longer. The speeches take longer and the listening takes longer and is more attentive, fewer interruptions, and much more attention to minority voices as well. That's advantage. It seems to me those are considerable advantages when we're trying to write rules of a game, rules that politicians will have to live by and the rest of us will have to live by as well. Secondly, the consensus means that at the end of the day, the politicians have agreed not just on a set of prescriptions, they've agreed to do politics together in an agreed fashion. That is very different also from the other two methods. And thirdly, with respect to Indonesia and Tunisia, there were two very interesting reactions after those processes. The American political scientist R. William Little, who's a very well-known Indonesianist, wrote something after the conclusion of the Indonesian process that really struck me. He said, by the time the process was concluded, everybody knew everybody else's preferences. Everybody knew everybody else's aversions. Everybody knew everybody else's red lines, and they understood what underlay various positions that were taken. In other words, what you get out of this proceeding is a greater understanding among politicians of why other politicians are behaving in the way they do. You can hardly underestimate the importance of this kind of understanding. Now, interestingly enough, there's a Czech political scientist by the name of Teresa Germanova, and Teresa Germanova wrote something about the Tunisian process. She's a Tunisia specialist. And she wrote about the Tunisian process, that by the end of the process, everybody knew everybody's red lines, everybody knew everybody's preferences and aversions, and everybody understood why everybody was doing what everybody else was doing. She said almost the same thing in almost the same words, and she had certainly never read Bill Little's book on Indonesia. In fact, I think she probably knew nothing about the Indonesian process. So here you get an output that you're not likely to get from other modes of proceeding. Now, I want to emphasize that this is that whether this really leads to democratic commitment is a hypothesis or a theory. It's an argument. It's not a finding. It's not a solid empirical finding. And I make that very clear in chapter 1 of the book. But it does seem to me that there are these advantages. And there are disadvantages to negotiation. If returns to bargains that are made are uneven down the road, you have a temptation, that is, the disappointed side has a temptation to renege on the bargain. There's also the possibility under these conditions that there'll be willful misrepresentation of what was agreed. There's been a good bit of that in Malaysia with respect to 2 clauses, Article 153 of the Constitution on the special position of the Malays, and 2 articles having to do with the religion, whether Malaysia is a secular state or whether Islam is an official religion of the state. With respect to voting, of course, it stands to reason, even if it's voting by a supermajority to enact provisions of a constitution or the whole constitution, that those who lose in votes are disappointed, and they may also become disaffected. So if you're talking about democratic commitment, it seems a priori, at least, that there would be great advantages to consensus as against negotiation and voting. Now, there are many other topics treated in the book, trade-offs between compromises and clarity. And by the way, several of the people who are here this morning, Singapore time, are cited for some of these propositions in the book. There's a lot. There's a good bit of discussion in one chapter of how to draft in order to minimize the possibility of reneging and so on. And there's also a chapter on external advice and public participation, and particularly the admonition that there should be extensive and intensive public participation, which is supposed to be conducive to democracy. My own view is that advisors like it because it travels well. It's the one thing they can say about processes that they think is invariable from one country to another, and it allows them to go to another country without knowing all that much about that country, and many advisors do, not all do, but many advisors do that, and it allows them to give some advice on how to get the thing started. And it always is start with public participation. My own view, by the way, is that public participation can be much more valuable if you do it after you have something to show the public, so the public can provide some feedback. But what I want to point out here is that there's absolutely zero evidence for the effect of public participation on democracy. There are people who have tried to find this effect, and I've laid out those studies quite comprehensively in the chapter on public participation. And I've shown that there's no evidence to demonstrate it. In fact, one research group has retracted its findings in both an article and a book that public participation was conducive to democracy. They say actually that its inclusion by elections that is conducive to democracy, which is the starting point, after all, where we began this. Furthermore, you get a lot of responses from members of the public when you ask them, what do you want in this constitution? Would you like this or would you like that? Responses in which they throw up their hands and say, I don't have the expertise to decide whether I want this or that. But that's what you're there for. Your job is to try and frame a constitution that will receive public acceptance. And of course, we know that public participation can be abused by extremists. They can bring out crowds. And sometimes in ethnically divided countries, this can be a very bad thing to do. So with that, maybe I will recede and await your comments. And actually, I'm looking forward to. I've been looking forward to this session, and I'm looking forward to your comments.
Thank you, Zon. You've given us a lot to think about, of course. So we'll move on swiftly to Dian. Dian.
Thank you, Jaclyn, and thank you, Kals, for giving me the opportunity to discuss this book. At both personal and professional levels, for me, it is always a privilege to be able to engage with and discuss Don's work. And of course, always look back fondly at the years spent working together at Duke and being mentored by Don. This is an incredibly rich book, both in terms of its ideas and evidence. And as always, Don, I am in awe of how you utilize and explain the case studies in such a nuanced manner, not just a superficial scratch of the surface, so to speak. There's certainly a lot to think about, as Jaclyn said, and to grapple with. But for my part in this discussion, I like to do two things. The first is to highlight a couple of key themes from this book in relation to the study of Asian constitutions and constitutionalism. And second, to consider through specific case studies in Southeast Asia and South Asia, why thinking about constitutional processes matter, given especially what we see today as a crisis in democratic commitments around the region. What I mean by that is this. By now, we would have been well fed with analysis and information about constitutional retrogression or the global phenomena of democratic decay or decline. And Asia has not been spared from this. And for me, fundamentally, this trend or pattern has emerged due to growing challenges or assaults against democratic commitments. So really the thrust of my comments is on why, or to the extent to which constitutional processes is significant in securing or sustaining democratic commitment outcomes, especially for severely divided societies in the region. Now, if we think about countries undergoing democratization or democratic transitions, norms of democratic and constitutional observance do not always develop at the same pace as new institutions or structures put in place to achieve democratic outcomes. So there is always a risk that democratic institutions, norms, and practices are ignored or even later reversed, even some years after democratic transitions. Now, this book, for me, highlights an important case study from Sri Lanka, which I will come back to in a moment. But one would not be hard-pressed to find attacks against democratic constitutional commitments in countries like Indonesia, for instance, or Malaysia. Now, one most recent example, which our Indonesian friends here in this webinar are no doubt monitoring, is the talk of amending the Constitution for the first time since the post-Suharto constitutional amendment exercise to extend presidential term limits. There has been extensive writing, including Don's book in 2012, the one that he showed just now, on the commitment to limiting presidential terms as a means of preventing the kinds of excesses of power under Suharto. And this commitment was a product of widespread consensus in the MPR at that time. Some of the personalities involved in that amendment process are still in the MPR today. So the possibility of an extension for me is clearly an attempt to undo that commitment. So I find this underlying theme throughout the book of how do we make democratic commitments durable, enduring, and self-enforcing a very important and interesting one. And the focus on processes, as opposed to just the specifics of design or substance of particular provisions, is an important contribution to our understanding of constitution making as a whole. So for the time that I have left, I want to engage with the ideas of inclusion and consensus in constitutional processes. The idea that consensus in constitutional processes could make more durable constitutional commitments is a compelling one. And Don offers several clear examples on that. So here are some further specific thoughts. The first is that the book makes a clear conceptual distinction between consensus and compromise, but it seems to me that in practice, the lines may often be blurred. In particular, having read the examples from Malaysia, Indonesia, and Fiji, to name a few, it seems that compromise may sometimes be a means, an important means no less, to secure consensus or lead to consensus. I'll add here one clear example from Indonesia, the provision on religion, Article 29(1) of the Constitution. There were factions in the MPR at that time who were bent on reintroducing the controversial 7 words into the Constitution as part of Article 29, that the state would be obligated to enforce Sharia for Muslims. Now, although that faction was relatively small, there were fears that the MPR could not achieve a consensus on Article 29(1). And so the compromise was to include religious values as one of the bases for limiting rights. So here again, compromise, ambiguously worded, without much deliberation on its potential effect, because at that time the MPR was running out of time, was important in securing consensus on Article 29. And the commitment embodied by Article 29 is that Indonesia is a pan-religious state underpinned by the principle of the belief in one and only God. Second, consensus can be important in securing constitutional and political stability, especially at a time where threats of defection, uncertainty, and instability loom large and could risk a collapse of the constitutional order altogether. In particular, I do not think that consensus and inclusion that consensus and inclusion can produce a set of agreement on the procedures and the rules of the game, even if the agreement is imperfect or temporary. And as Don highlights in his book, with such processes, we can leverage the reputational costs for reneging against the agreement. So here I want to highlight the significance of inclusion and consensus in processes not of constitution making per se, but of making constitutional soft law. Malaysia offers a very good example of this. Last year, in September 2021, following defections from the government coalition and the appointment of yet another new prime minister, the government and the opposition coalitions entered into what they called a memorandum of understanding to facilitate reforms and governance until the next election. So in terms of inclusion, The drafting of the MOU included second echelon leaders on both sides, primarily those with legal backgrounds, and the drafting was done in over 10 stages, allowing demands on both sides to be ironed out, dropped, or modified over time. And there was a consciousness to ensure that the wordings were as precise as possible and legalistic. Substance-wise, the MOU makes clear the role of a democratic opposition. It embodied the agreement that the opposition will not vote the budget down, but cross-party consensus is to be reached before that budget is tabled to Parliament. And there's a host of provisions covering parliamentary reforms, judicial independence, amongst other things. Now, although this MOU is not legally binding, the details are widely publicized, making it very difficult, in my opinion, and potentially politically costly for either side to renege on the agreement. Again, this example shows what compromise and, more importantly, consensus can offer. And this can be compared to the lack of these elements in the failed amendment to restore the position of Sabah and Sarawak as equal partners in the Federation under the previous government in 2019. In that instance, 59 MPs comprising opposition politicians, as well as representatives from Sabah and Sarawak, abstained in the end from voting. And it later transpired that various quarters from both states felt aggrieved by the lack of agreement on concrete substantive changes with respect to the rights and interests of the two states. So these ideas on consensus, inclusion, as we see, they have great practical utility given recent events. So consider Sri Lanka as an example. There's a 21st Amendment now that has been engineered by the opposition SJB party, and it has been presented to the Prime Minister and to the Cabinet. And the amendment draws heavily on the 19th Amendment, which was reversed by the government in 2021. Now, as far as I know, the process of drafting this 21st Amendment was the work of the opposition, without including lawmakers from the government who undoubtedly have their interests and privileges at stake. So it will be interesting, in my opinion, to see how the amendment process and deliberations pan out over the next few weeks. To wrap up my comments, I have a few questions, two questions actually for Dian. The first is this: the book argues for processes that are broadly inclusive and that involve a high degree of consensus. Specifically, it argues for, as you said earlier, electoral means to create inclusion. I can definitely see the value of processes that are broadly inclusive. However, could there be, Dian, instances where broad inclusion, that is, inclusion of survivors of the old regime, would raise issues of legitimacy in the eyes of the public, especially in a context where there has been widespread disapproval or violent disapproval of personalities from the old regime? Again, I have in mind Sri Lanka here. And an additional point is, if widespread agreement is impractical for the reasons that I have mentioned, what would be a fallback option that is conducive to durable commitment? My final question and thoughts are these. Consensus and inclusion at point A may be conducive to durable commitment to participants at point A. But later, I can imagine political actors at point B might argue or find, for a variety of reasons, that they ought not to be bound by the commitments created at point A. And those actors would then proceed to challenge or depart from those commitments. I think to some extent, this reflects what happened in Sri Lanka after the Rajapaksas took over in 2018, and maybe to a lesser extent, what is happening in Indonesia today. You addressed Sri Lanka's case of defection in your book, Dian. So I wonder if you have any additional thoughts on consensus, inclusion, and the durability of commitments given the possibility of defection. I'll stop there, and I look forward to more comments from our two other discussants and some responses from Dian. Thank you.
Thank you, Dian. Thank you. I'm sure those are questions that Dawn will address them later on. So let's move on to Shamshad. Shamshad, on to you.
Yeah, thank you very much, Jaclyn, and thank you, Dawn and Dian, for wonderful remarks. Constitution making, as all of you in this webinar know, is very ubiquitous. Today, Chile, Tunisia, Libya are actively working on making or remaking their constitutions. But it's still there's work to be done to really understand this entire enterprise. And Dawn's book, I agree with Dian, is a very rich book and really helps us understand what constitution making really is. I will make 3 very quick comments if I get the chance. If not, I will make 2, and then we'll hopefully get another one. My first comment is where Dian left it about inclusion. Inclusion, of course, is certainly a value that could lead to more credible democratic commitments downstream. Looking at Afghanistan, that my work mostly focuses on, Afghanistan had like 10 different constitutions. None of them, on average, each constitution lived less than a decade. The only constitution that lived longer, for 3.5 decades, and what really was a stable constitutional government, was the 1931 Constitution of Afghanistan. And one reason for its durability in performance was because it was inclusive, as compared to a very liberal constitution that preceded it in 1923, and a very liberal, or in some scholars' view, the finest in the Muslim world, that followed it in 1964. I'll particularly come to the 1964 Constitution. In the tension that I think this broader level of inclusion may have for democratic commitments. Dian talked about the elements of a surviving regime who may be delegitimized in the eyes of the broader public. I'm thinking of actors and groups who may not have any commitments to a democratic process at all. So let's discuss this in the process for the crafting of Afghanistan's 1964 Constitution. Now, as a side note, this is a constitution that has been celebrated a lot, both inside Afghanistan and outside, because it's a very liberal democratic constitution. Although it did not help to do any practical things, any concrete outcomes, it really created the problems, in my view, that Afghanistan has suffered over the past 50 or 40 years, including the current crisis that we have. So Afghanistan lived under the 1931 Constitution for peacefully in some of an incremental democratic process for 30 years. In the late 1950s, a prime minister, Sardar Muhammad Daud Khan, who was the brother of a king, Muhammad Zahir, proposed to the king that this constitution is no longer working, we need to craft a new constitution. The prime minister was particularly concerned about the broader powers that the king exercised under the previous constitution. So in his view, a new constitution should create what he suggested to the king, a single-party parliamentary type democracy where the king will be a largely ceremonial figure and powers will be exercised by the prime minister being appointed by the parliament. The king, of course, becomes suspicious of the prime minister's intention and asks him to step down. And he does, in the hopes that the king will reform the constitutional order, and act on the prime minister's recommendations. And the king does initiate a constitutional reform process and tries to draft a new one, but not in the way that the prime minister expected. So he appoints a committee of his close confidants and writes a constitution, and that draft inevitably included a provision in its Article 24, which said that members of the royal family, the former prime minister, very ambitious, of very autocratic tendencies, that members of the royal family should not participate in the political process. Particularly, they should not become a prime minister or justice of the Supreme Court. So the prime minister suddenly finds himself surprised, what's happening? He asked the king to remove that provision, and he doesn't. he is not even allowed to partake in the process and not even to introduce his own representatives to be part of the constitutional drafting and later constitutional review commission and later the Constituent Assembly, the Loya Jirga, that functions as Afghanistan's Constituent Assembly ratifying constitutions. He doesn't let the prime minister to be part of the process. So the prime minister says, okay, it's fine. I can live with this ban, this disqualification. I will form a political party, and then through that, we'll participate in the political process indirectly. The king finds out that too, and adds another ban saying the members of the royal family cannot become members of the political parties either. He says, okay, fine, I'm abandoning my membership in the royal family. The king still moves on to amend that provision, adds another ban saying that membership in the royal family is permanent. You cannot abandon it. And that's how that constitution is ratified. The framers of that constitution argued that, okay, this provision was included important for two reasons. One was that we will let figures and Afghans from outside the royal family to participate in the political process, become prime ministers and occupy those positions. And second, Dawood is a threat to democracy. That's what they thought. Like the prime minister, the former prime minister is a threat to democracy. We'll have to disqualify him. Otherwise, he will create an autocratic presidency, basically, and will rule by one person, which was true when he overthrew the monarchy. He created exactly an autocratic constitution. So the prime minister is alienated, and he, from the day the constitution was ratified, he swore, in one historian's word, that he will not let this constitution take hold. And he was looking for an opportunity to topple the monarchy, and got this opportunity in 9 years. In 1973, he stages a coup and overthrows the monarchy. And that opened this disastrous period and episode for Afghanistan that we have witnessed recently. So this, in my view, that was a bad decision on the part of the constitution makers to really not be inclusive to the extent that to exclude people and actors who credibly had the power to threaten a constitutional order, to topple it, and he did. The other example that Don discusses in the book, to some extent, is the drafting of the 2004 Constitution of Afghanistan, and how that constitution was created. There too, we have this Islamist group or movement that has just been overthrown. I'm talking about the Taliban, whose ideologies is not acceptable to the international community at all, because they are not supposed to be democratic movements, a movement not having any sort of commitment to a democratic politics. And what happens is they are removed. They are removed from the constitutional drafting process. And if I get a chance, I'll discuss how they favored, the international community to some extent favored participation over inclusion, meaning that they did a remarkable public consultation and debate process, which made no difference at all. That's one of the themes in the book. But they excluded the Taliban, which was far more consequential 20 years down the line. So the Taliban wanted to be part of the process, but because of their ideologies, and they were considered to be a group too weak to threaten any constitutional order, they were not worth to be included in the process. Some justified that because they think of, okay, including a group who does not have any commitments to a democratic process is not worth it. It's fine to exclude them, but of course the consequences of that we have seen in 20 years today. That the Taliban basically regrouped and toppled the entire constitutional order and now in power again. So the question then is it okay to remove from the constitution making process these types of groups or actors who don't really have a commitment to the democratic process? Of course, the downside of that exclusion is the downfall of the constitutional order at some point down the line. That was a comment, and really, I don't know if it was a question, but to see how the themes developed in this book can help us understand some of the very complex and understudied cases too, like the Afghan constitution making process. My second comment is about the idea of deliberation, particularly deliberation in the deeply divided societies. And of course, talking about divided societies in front of Donald Horowitz requires courage, but I have kind of tried to summon that to make this comment. Deliberation in the book on the deliberation, there's a very interesting argument, I would say, that particularly deliberation in all contexts might lead to consensus, but particularly it's more important, is emphasized in the book in divided societies. Why that is important in divided societies? Because deliberation could lead to kind of some sort of reasoned, principled arguments about the political process that could then push participants or actors to the constitutional bargain or process towards an answer that is considered to be a good answer. But in divided societies, at least in Afghanistan, if I talk about, sometimes there is no good answer. In deliberating on trying to find a good answer that may not exist might be counterproductive. Or in these cases, the good answer, I think, would be no answer at all. And that is why the scholarship on constitution making in divided society, I'm talking about Hannah Lerner's work, particularly on incremental constitution making in divided societies. And that's why in constitutions in divided societies tend to be incomplete contracts. They are very vague and include contrasting or conflicting provisions or norms within the document. Rosalind Dixon's work on constitutional design differed makes that point very explicit, why you see some constitutions which incorporate conflicting provisions at the same time. So deliberation when it comes to divided societies, in my very humble view, might not lead to consensus, at least in certain types of democratic divided societies that are post-conflict and really conflict-prone, where mere disagreements could really lead to violence on the street. Again, sadly, I'm talking about Afghanistan here. So if you keep deliberating, if you keep negotiating or discussing a question or a design aspect over which the groups disagree deeply, that deliberation might only lead to this understanding of how these parties who are deliberating are disagreeing too deeply. It may, in other words, bring to the surface the disagreements that the parties have, and will lead to dissensus rather than consensus. I will just stop here to the maybe question will be whether if deliberation does not lead to a good answer, then could we keep deliberating on certain questions of constitutional design? Yeah, thank you.
Thank you, Shamshad. Your comments obviously also overlaps with Dian's earlier question to Dawn about whether a process needs to be broadly inclusive, in particular, whether if including a group that is deemed to be undemocratic or prone to violence could actually legitimize or delegitimize the constitution making process. So I think these are very, very important questions for us to grapple with. But before I give time to John, we have with us Ross Dixon, who will wrap up the comments. Ross.
Thanks so much, Jaclyn. Thanks so much for the opportunity to join this really fascinating panel and to celebrate what is a very important and interesting book. As you said, Jaclyn, it's always a pleasure to join CALS and to celebrate the wonderful work being done there, as well as the connection between the Gilbert and Tobin Centre and CALS that we've forged in recent years. So Don's book really is an important contribution to understanding what we can and can't say about good constitutional process. And I think that the call for more inclusion, more deliberation, and to a de-emphasis on popular participation relative to, if you like, an elite party and sort of interests that have to be accommodated in order to have stable democracy, being at the table and encouraged to deliberate and discuss, not simply to bargain, is a really welcome intervention in the debate. I think one needs to read the book as a corrective against other contributions that might de-emphasize deliberation and emphasize voting and or overemphasize participation. I want to divide my remarks into three. The first is about the limits of consensus, and I think really Dian and Shamshad have already highlighted this, but I just want to draw it out a tiny bit more. The second is about a theme we haven't talked about, but which I was especially interested to read in the book because I've thought about it myself with Tom Ginsberg and individually on specificity and how detailed or long or specific a constitution is. And then the third is this theme around participation, which Don is more sceptical of as compared to inclusive deliberation. So on the first point about consensus and inclusive deliberation, as I've said to Don previously, my immediate instinct in reading the book was to say, well, that makes sense. But the question is, what is the level for sufficient consensus and who gets to be at the table? And, you know, as Shamshad says, does the Taliban get to sit at the table? You know, does Hezbollah do the outgoing ancien regime in Cambodia, and Malaysia as an example is also really useful. And I think Don has an answer to that, but I just think it's a really tricky one because it's almost like infinite regress, which is if we need sufficient consensus among groups, but we exclude some, then those people are going to be the people trying to unravel the deal and the constitutional consensus, no matter how principled it may be. If we include them and they're inherently unreasonable from a democratic constitutional perspective, well, they're not going to agree to fair terms of cooperation because they don't believe in the basic precepts and premises of fair terms of democratic government. And so it's a really hard problem, which is not new and we're all familiar with, which I think Don does grapple with some in the book, but I don't think can ever fully answer, and it's worth just noting that as well as hearing his response. The second is about specificity. So Don makes the claim in the book that in general, more consensual constitutions will be longer and more specific. And he does note the work of myself and others, Hannah Lerner and others saying, well, sometimes, as you've said, Shamshad, deferral can promote consensus. He sort of raises some doubts about the stability of that. And he also notes the work I've done separately, raising the difficulties of specificity as a vehicle for specific consensus if it leads courts to be more hostile and less purposive in approach to the interpretation and implementation of a consensus constitution. But nonetheless, he suggests, in general, one would expect consensus constitutions to be associated with longer constitutions, more specific constitutions. And indeed, he suggests there is a trend, as Tom Ginsberg and others have also shown, toward more specific constitutions. I want to just suggest two quibbles or challenges. The first is, as Shamshad, you generously alluded to, Tom and I have done work on what one might call insurance swaps, or where highly detailed provisions can be the product of a bargain or compromise of the kind that Don is not very supportive of. You get a property clause that is going to please your supporters. We get a social rights clause that's going to appease our supporters. The two are completely contradictory in substance, but we'll leave it to the courts to figure out how to mediate that tension. That is a form of raw bargain or compromise that Tom and I label insurance swaps that pleases both sides through essentially highly specific but inconsistent provisions where elite interpreters down the track have to resolve the inconsistency. And so it is an instance of specificity, at least as measured in large N studies of length and detail, rather than qualitative studies which would point out that highly specific words that conflict are actually deeply ambiguous. Those sorts of measures will tend to lead to a conclusion that consensus is there, but actually I would suggest they are instances of the compromise constitution in action. The second thing I want to draw attention to, again, apologies for the self-referential nature of this, although of course, one's ideas are always formed by one's own thinking on these issues, is to think about the work that David Landau and I have done on what we call the tiered constitution, where we say, actually, it's really important, and this is in response to the work of people like Nilla Versteeg and Emily Zakin and others, and it has very nice continuities with the work of Richard Albert and his escalator work, is to say that you need to divide constitutions into different tiers or different levels when you think about both amendment difficulty and specificity. And a constitution that's highly specific around who has to collect the trash is a very different constitution from one that is extremely specific as to the regulation of basic rights and freedoms or the powers of the president vis-a-vis the parliament, etc. And so one of the things I think, Don, that would be useful to think about is when consensus leads to specificity in terms of different domains of constitution making or different tiers. Because I do think that the best constitutions, as we understand it, are relatively flexible and abstract on one tier and specific and entrenched on another, and that it may be useful for you as you develop this work further to think about when the consensus constitution might lead to, if you like, agreed principles that are entrenched but relatively abstract versus agreed provisions and norms, which I would call the ethnic power sharing aspect of the constitution that is going to be specific and quite entrenched, or more flexible. So sometimes you can flip around the relationship between abstraction and flexibility. Abstraction could be entrenched and specificity be flexible in ways that we suggest might or might not be desirable. That tiering idea also informs my response to your comments about participation. Your arguments should be read, I think, as a corrective against the over-enthusiasm for participation all the way down, not as a skepticism of participation as valuable at some point or at some stage. I think you would agree with that. But it may be that in response to your anecdote about our Ugandan colleague who says, I don't understand the difference between Kelsenian and concrete review, what am I supposed to say about that? That really we need to tier participation, that participation needs to be relatively education focused rather than deep and consultative when it is about what you might call the structural detailed constitution. Highly specific structural and specific norms are really not ones that ordinary people have much capacity or interest in comment on. Principles, values, basic rights and norms that might be on the other tier of the constitution might be ones where people have views and where it's more natural for people to express a view about rights, values, principles, founding commitments. And I think it might be worth not only distinguishing the intensity of participation and its degree, but also where it's focused. And the best forms of participation will be focused on the tier of the constitution or the part of the constitution that does speak to ordinary people, not who's responsible for trash collection as between the centre, the state, the provinces or the locality, both in terms of logistics and cost. And equally, very hard to see how very specific provisions around what you call the centripetal constitution are subject to popular participation rather than general principles, values, norms, rights, etc. And so I think it might be worth, as you develop the critique of participation further, not only to understand it as a corrective to the current wave of enthusiasm for it as a panacea, but also an effort to particularize when and how participation can be most effectively harnessed as a tool for reinforcing democratic stability rather than as a kind of peon to, or sort of fairly throwaway understanding that doesn't actually reinforce inclusion, stability, and true democratic legitimacy. But it's a really important book, John. I learned a lot from it. One of the things that I'm always so in awe of your work, and like Shamshad and Dian reading it, is just the sheer breadth of your knowledge of comparative developments and your attention to real nuance and contextual aspects of every case study that you study. I think that, it really is a kind of epitome of the kind of qualitative, empirical and interdisciplinary scholarship that we should all aspire to do. And it's a real pleasure to read it and to celebrate it today.
Thank you, Ross. Well said, well said. So, Dawn, on to you. You have about 10 minutes to respond before we open it up to the rest of the audience here.
Well, I scarcely know where to begin, except at the beginning. I'll begin with Dian. But as far as the comments go, they talk about rich comments. These are enriching comments. And I'm not sure that I'll be able to do justice to the comments, and certainly I won't be able to do justice to any serious critique of any of the assumptions underlying any of the comments, or any of the comments themselves, for that matter. Dian is exactly right that I'm just going to try and plow my way through, by the way, otherwise we'll be here forever. And so you'll forgive me if I'm brief in summarizing some responses. Dian, as to Article 29, 29.1 of the Indonesian Constitution, with respect to religious values, Dian describes that as a compromise. It's really the only compromise in the Indonesian constitutional process, and it has had inflated results. That is to say, I would describe them as, to say it politely, negative externalities. I particularly love the idea of a consensus in making constitutional soft law. And if I had to look for an example, I would look to the MOU in Malaysia, which is exactly what you cited. And actually, I'm very happy to hear more about it. I haven't followed the current move to reinstitute something like the 19th Amendment in Sri Lanka, so I have to pass on that one, although I'm not surprised that there would be such a move at all. The two questions, you had two questions. One, can broad inclusion increase issues of legitimacy if the old regime is included? I have a simple answer to that. Do it by elections. Whoever wins the election is included, and whoever doesn't win the election is included. And by the way, I can say the same thing to Shamshad's remark about the Taliban. If the Taliban are as faithful to Islamic texts as they purport to be, and if the population of Afghanistan is as knowledgeable as one hopes it is about those texts, well, the Taliban will be elected. And if the Taliban can't get elected, it's not included. And if it's included and it becomes a spoiler, well, there are ways of dealing with spoilers. I have a lot of stuff in there. I can't go through all of the devices that were utilized. The consensus committee in Tunisia, the failed Yemeni experiment in trying to find consensus, which I think was a very, very well conceived one. It's just that conditions in Yemen didn't permit it to succeed. Everything in Yemen happened much too early. Good ideas were killed at a very early stage because they came at exactly the wrong time. What happens when? How can you? The question about departing from commitments that Dian raised, when can one anticipate departures from commitments? That's not quite the way she put it, but I like the formulation that says you try to increase the costs of departing from commitments. Of course, you want to depart from commitments when conditions change, but that too can be a feature of post-constitutional consensus. Consensus doesn't have to end, and isn't likely to end actually, with the passage of a constitution based on consensus. It didn't end in Indonesia. And some people say, oh, that's terrible that it didn't end in Indonesia, that shows that there's cartelized government. And it didn't end in Tunisia either up until the coup. That is to say, early on, they had very great difficulty forming governments because they didn't oppose each other sufficiently. They had understood so much about each other, they had trouble forming governments. So there is a possibility of an unforeseen consequence that isn't exactly what one might wish to see. Let me just see if I can. Well, I think I've answered Shamshad's question about the exclusion of the Taliban. I think elections would have been a good thing. And if you can't have by the way, Afghanistan was said to be ripe for a loya jirga on two grounds. One, that it's the traditional way in which we make constitutions. How traditional it was, I'm not so sure. I don't know how far back the loya jirga really goes. But the other the other reason was the conditions aren't right. We're going to have warfare here. We can't have democratic elections at the moment. And of course, there was an underlying reason, and it had to do with the ambitions of Hamid Karzai specifically. But if you can't have elections, then there seems to me a very good and simple solution, and maybe you want to call it a short-term Hannah Lerner solution, and that is you make a temporary constitution. In Iraq, by the way, they had a perfectly good temporary constitution called the Transitional Administrative Law, which was drafted by Larry Diamond and 2 Iraqi exiles, actually. No Iraqi who was in Iraq before the invasion, if I remember correctly. I can be corrected on that, but it was 1 American and 2 Iraqis, and that TAL could have lasted a long time. They didn't have to race to a constitution, to a final constitution. The American government was very much in favor of their racing to a final constitution, and some people said that was because the Bush regime, which was losing support for the war in Iraq, wanted to show progress to Americans. Wrong. I have a lot of evidence from people who were actually in on this conversation and told me independently that it wasn't for that. It was to show progress to the Iraqis when things started to unravel there. But either way, it was the wrong thing to do. To rush that constitution was a terrible mistake. And in fact, the U.S. administration knew that it was having this problem, because it knew perfectly well that the Sunnis were being excluded from the conversation, which was taking place entirely with the aim of reaching a deal between the Shia and the Kurds, which eventually they did reach. And the Sunnis never really had their say, and that's very much what contributed to the various Sunni uprisings that proved so difficult to put down in Iraq. Let me just see what else is here. Yes, yes, and the threat of violence. If there's a threat of violence, what you need to try and negotiate before you can negotiate a constitution is a peace agreement, and the two shouldn't be done together. The peace agreement has a certain set of exigencies. The constitution has a different set of exigencies, and the two should never be confused. Roz has a longer list, and I'll try to do justice to it. The limits of consensus. If some people are, if some elements in the inclusive body are undemocratic, how does one reach a consensus under these conditions? Well, I want to again advert to the various devices that are enumerated in the book. They're too specific for me to recapitulate them here, but you try those. And it may very well be that some constitutions cannot be made by consensus. That is to say, I'm not throwing away the possibility of negotiation. Consensus documents often need to have a negotiation waiting in the wings when consensus fails, or even voting when consensus fails. And often there's voting at the end of even a consensus constitution, and one can look at the vote to see exactly how much approval it managed to garner. Highly detailed provisions can be the process, can be the product of excessive, well, they are, they're synonymous with excessive specificity, but what about the problem of conflicting provisions? As it happens, I'm working diligently this day, yesterday, last week, last month, and will be working for the next several weeks on the Indian Supreme Court's response to the ethnic problems in Northeast India, where the tribal groups have privileges that deprive other people from certain other tribes and other people who are non-tribal people in the Northeast Indian states, of which there are 8. They actually have constitutional provisions having to do with the creation of those states, which are amendments to the Constitution, which provide, along with the so-called 6th schedule, which governs in general how these arrangements are to be dealt with, that are in conflict with the fundamental rights provisions of the Indian Constitution. But here's the thing. These came much later in response to very different exigencies, and they are amendments that really are very hard to square with the rights provisions. There are some formal ways of doing it. I think they're really quite unsatisfactory because they would deprive people of a lot of rights, even if they might be justified by the text of the original Constitution, not merely the amendments. But I do think that inconsistent provisions are much less common when you have a long process with a lot of people going over the draft 1,000 times to be sure that everybody's on board with it. But then you're likely to have when a spate of amendments is produced many years later, which is the Indian case, because the Northeast states were created mostly out of Assam. Well, there was also Sikkim also joined, but these states were created very much later after difficulties arose within Assam, which was a very highly multi-ethnic state. So I think one has to take account of timing with respect to inconsistency. When consensus leads to yes, consensus may lead to specificity and thereby impair flexibility. I don't think that is necessarily the case. I think that the impulse in many cases is going to be to solve certain problems with very specific provisions because everybody knows otherwise they will remain problems, and to leave and to state more general principles for other kinds of problems which are not likely to lead to what did I say, problems and problems. Well, you know what I mean. It's getting late here. I just want to point out that the hour is getting late and my incoherence is increasing with the hour. But in any case, what I'm trying to say is the best constitutions, of course, have both. They have a certain degree of flexibility, but they also have specificity on matters that are otherwise likely to be highly divisive. And I don't think that consensus really in any way inherently rules out flexibility. Actually, it's a very good empirical question, in fact. But the whole, everything that I've put in this book about consensus raises empirical questions, so I'm not sorry to see yet another one. Participation, finally, participation can be tiered. Educated participation versus consultative participation. I agree 100% with that. And that's why I think that the right time for participation is not before the Constitution drafting gets going, but later on. But then we can find out what the feedback is. That's useful, a useful form of positive participation, and we can also help to train people in what it is not to train people, but to inform people about what it is that the Constitution makers have been thinking and what it is that they're drafting, and to see how those things sit, at least preliminarily, with the public. That's a very different kind of operation. It's inconsistent. I want to point out a lot of what I've said is inconsistent with sharp deadlines. And I think sharp deadlines are, generally speaking, a very bad thing. Whenever we've had rushed constitutions, we've had a lot of bad constitutions. And that goes, by the way, of course, for Afghanistan. In the 2004 Constitution was created in a very great rush. And I can't help but think that there would have been, that a better constitution could have been composed with much more serious efforts to include people, to include independent people, not people who are beholden to political leaders and therefore had to follow what their dictates. But independent people could have been, if not elected at that stage, at least co-opted by some semi-democratic process and would have produced a much better result. But I agree completely with Roz. By the way, I'm very grateful for all of these comments. I was taking copious notes the whole time, and I don't usually take copious notes unless something really outstanding is happening, and I certainly don't do it after 10 o'clock in the evening. So I thank you all for this. And and thanks to Cal for organizing this.
No, it is our pleasure, and thank you for all of those very rich comments from all four of our panelists today. We have some time for Q&A. As mentioned, please use the Q&A function at the bottom. If you'd like to type your questions, please type them in there directly. But if you would prefer to verbalize them, please also note in the Q&A, and I can allow you to talk. There's a function for that. Would anyone like to start the ball rolling? Well, as we wait, I actually was struck by something that you earlier said, Dawn, about Yemen not having had the right ideas, but at the wrong timing, right? So it's sort of a question that about preconditions. So in your book, you talk about starting conditions, about crisis and all of that. That may be a starting point to propel sort of rethinking about the Constitution. But I wonder if you thought that there were certain sort of preconditions that we could identify with regards to, you know, in a much more systematic way, with regards to, you know, ensuring a much more successful constitution making process. I'm thinking, you know, just looking at some of the comments that have been made about expertise, right? The idea that you or constitutional consciousness or certain constitutional cultures that needs to, that, you know, could actually, that needs to be present before a constitutional process could actually take place in an effective manner. What do you think some of these preconditions could be? If I may, one sort of idea could be that instead of starting at the top, which is sort of looking at how, you know, constitutional democracy could work, perhaps one of the ideas to formulate or foment some kind of constitutional culture could be to start at sort of a very decentralized forms of democracy, right? Having village elections, provincial elections, all of that. Will that actually help in inculcating a certain democracy-minded populace in order to establish some preconditions for a much more successful constitutional process? So what are some of these preconditions do you think we should be looking at?
I'm not sure that I can name them, to be honest with you. And I'm not, and I'm wondering if maybe the reason I can't name them is I'm a little skeptical of them, because if one talks about preconditions, that's one way of stopping a process. Or delaying a process. And it may very well be that the process creates the conditions rather than the conditions are prerequisite to the process. So I'm just not sure I know. And by the way, if we are to have inclusion, democratic inclusion means through elections. We're not talking about inclusion of elites chosen because they have money or because they have power in some region or other. We're talking about elected representatives through free and fair elections. And I've pointed out that there are the two main electoral ways of doing this, and it may very well be that in most cases, because many groups are pretty well spread through the territory, even first past the post might work for this. A simple system like first past the post. You don't want to have a very complicated system for these elections. Many people say it has to be PR because otherwise you won't have adequate minority representation. This idea has actually been refuted on empirical grounds by a couple of writers who show that the demography is in most countries does not require this. But as I say, I think the election campaign is going to be one of the things that raises the consciousness. The election campaign for either the legislature that is going to work on this or the separately elected constituent assembly that's going to work on it. As I say, again, you don't need to rush it. Get it going and have a campaign that's informative. And people will then say, you know, I like the ideas of this person about where we're going with this. I'm not so sure about the ideas of that person. So I mean, this is an off-the-cuff remark because I haven't really thought much about preconditions. But I do think that there are ways of getting these preconditions without saying, well, only 70% of countries are going to be able to have a constitutional process that works because the other 30% don't have the right preconditions. And your idea about doing it at lower levels. This is an old British idea, you know. The British colonialists love to have local elections first. And they love to have elections without very strong results. That is to say, strong results in the sense of empowering the power holders. The power holders first, in many colonies, the power holders got portfolios over 3 or 4 of the major areas. In fact, they were the minor areas, so that they got some practice. The British loved practice. Being pragmatic people as they are, they They admit to being pragmatic people, and actually they are pragmatic people when it comes to these political and constitutional matters. And that's the way they wanted to do it, by slowly inculcating democratic norms at the local level. It would be very interesting to have somebody really study this. And it's a great dissertation topic, by the way, because you can use selected countries. And somebody should study what the result of some of these experiments really was. I'm a bit skeptical about some of it, because there's no place where the British were more inclined to experiment than Sri Lanka, because there was universal suffrage in Sri Lanka at the time of the Dannemora Constitution, 1931. And the Sri Lankans practiced a very good democratic form of government until the Buddha Jayanti of 1956, when everything hit the fan. And SWRD Bandaranaike proceeded to, by the way, his name, while we're waiting for comments, I will tell this little anecdote. SWRD Bandaranaike, I used to do this with students, maybe Dian remembers. What does SWRD mean? Who is SWRD? Well, the D stands for Dias, a Portuguese name, but for Sinhalese, not for Portuguese. There are Portuguese in Colombo. The Dias Bandaranaike family was a very, very prominent family, headmen actually of villages, and very, very wealthy, high caste Sinhalese of the Goyagama caste. SWRD, Solomon, West, Ridgeway, Dias Bandaranaike. West and Ridgeway were colonial governors. And SWRD Bandaranaike in 1956 changed from his trousers to what was called at the time native Sinhalese dress, and began to learn the Sinhalese language so that he could speak to, well, he learned it between 1948 and 1956 so that he could speak to people in Sinhala rather than in the English with which he was raised. He also changed his church from Anglican to Buddhist. So there you have it, and he is identified, I think, with a profound failure of the origins of the failure of democracy in Sri Lanka. So maybe that experiment didn't work out so well. Now I've filibustered now. Are there comments and questions?
I had a follow-up on Sri Lanka, if I may, Jaclyn.
Sure, go ahead.
Can we test on, I think there might be some participants in the audience who are experts on Sri Lanka, but can we test your proposition about the line between inclusion and blocking devices in the story you tell about? There was that moment in Sri Lanka where it looked like there was the possibility of a consensual agreement that might actually deal with interethnic conflict. And you tell the story beautifully in the book, and then you say, yeah, but then both sides went back to their corner and were worried about their base and losing electoral appeal. Is there any way, that your ideas, whether it be the how do we generate consensus or how do we design institutions, so as people to have the incentive, is it leadership, is it your blocking devices? Is there anything that could have been done to save that moment of hope in the politics of consensus in Sri Lanka?
Yes, there were three distinct problems, and one of them would certainly have helped. The president and the prime minister, who were enemies almost from the day after the election, refused, although the prime minister was to chair the Constitutional Committee, he never showed up. And the president, who originally said that he didn't want to leave the constitutional problem for the next generation, proceeded to forget about his own commitment also very early on. So that's one thing that would certainly have helped a lot. But in addition to that, they had three other problems, actually, not just two. One was they wasted a lot of time at the beginning on public participation, which in this case just told them everything they already knew. How many times do you have to be told that most Sinhalese think one thing and most Tamils think another? You don't need to have a public participation process for that purpose. Later on, an educative one you definitely needed in Sri Lanka, because otherwise the public wouldn't have accepted what they were going to do. So that's one thing. The second thing is, and they also had other administrative difficulties getting started, and along the way they had difficulties with their experts. So the result is that they were very, very slow. And in fact, at one point, they wanted a draft from the experts. The experts failed to give it to them. So they presented ideas in the form of statements and questions. By the time they were at that stage, elections were imminent, local elections first, and the polls already showed that the Rajapaksas were on their way back. So you couldn't keep the president's people on board anymore, because his people were a splinter of the Rajapaksas party. And at that stage of the game, the jig was up. So they really had much less time than they thought they could take with this. The apportionment of time was very, very important. And that just had to do with elections. Now, in a different polity, of course, the elections wouldn't have mattered as much. And in fact, in other polities, the elections could legitimize the constitution. That's what did it in Indonesia. The opposition was very fearful that Habibie was going to be the successor to Suharto in autocratic methods. And he said, nope, we're having free elections within a year, I promise you. And his promise was deemed to be credible, and he delivered on the promise. So that was a completely different story altogether. The elections there contributed to legitimizing the process, and it wouldn't have been a very great problem to have the next set of elections while the process was still continuing. It would have resulted in some marginal changes, that's all, in the composition of the body.
Shamshad, you wanted to
Yeah,
jump in?
Yeah,
sure, go ahead, please do.
From the participants, just wanted to make a comment and maybe I can throw an idea out there to all of you to discuss for the remaining part of time is the idea of compromise that Dian in her comments kind of alluded to. I was concerned that of course, in the book, there is this idea of a little, I think, suspicion of compromise and then a preference for consensus is obvious and for obvious reasons. If a constitution making process is inclusive and includes all electorally significant factions and groups in the process, then there may be some sort of inevitability about some type of a compromise, because under certain circumstances, without a compromise, a constitution may not be like, it will be a little hard, if not impossible, to be agreed upon in time one. So I was thinking of is the timing of the compromise important? Is it, if I put it for the lack of better words, is it okay to sacrifice consensus in favor of compromise during the constitutional drafting moment? Purposefully not using the constitutional moment, but the constitutional drafting period, the time that constitutions are written, it's usually a time that is of deep political instability. If compromise can get us through that period and down the line, if that creates some sort of opportunities for misinterpretation or even the change of conditions leads to a better treatment of one party, is that a price to be paid for a compromise in time A during the drafting period that could get us out of some sort of a more serious political instability or even crisis, if that gets us over that, and then down the line, if it creates some sort of opportunities for political or for misinterpretation, should that be okay? Like, is that a price to be paid, or no, at all times compromise should be avoided?
May I take a crack at answering that? Other people may have their own responses, but a compromise is not a dirty word to me. It's not a dirty word in the book either. It's a fallback, that's all. You can't have consensus, then you can have compromise. And many constitutions have a mix. In the Tunisian constitution, they had a great difficulty over one article, and in the end, they produced a sort of incoherent compromise just to get finished. That article obviously was in need of revision. I don't know when it would have been undertaken. But no, I think, as I say, compromise always has to be available as the fallback when you can't have consensus. And voting is the fallback for compromise when you can't even have compromise. So I don't think a constitution should fail because of the perfection standards that Horowitz says are required, and those standards are favor consensus. No, sometimes the world is a messy place and you can't quite get a consensus, so you get a compromise. And sometimes you can't get a compromise, you have to vote. So, but I do still think consensus is superior. I think it's a better way of making the document if you can do it.
Dian, do you want to also jump in on this?
Not on this issue specifically, Jaclyn, but just as Don was talking about Sri Lanka in response to Ross's question, the experience with the previous constitution making process under the Sirisena government and the local elections issue. So I wonder if that can be used to think about your comment, Jaclyn, earlier about this whole idea of building constitutional culture from the ground up, by having local elections and so on. In the Sri Lankan experience, they had local elections, yes, but they just returned an authoritarian government, and then the whole process just, completely derailed. So that's just something that I thought about off the kind of top of my head when Don was talking about Sri Lanka earlier. If you have any further comments, Don.
No, but I want to yield if there's someone from the audience who wants to speak.
I think the audience seemed very, very content to hear all of you speak about and share your ideas for now.
Well, I don't have any instant reaction to the Sri Lankan point, but I think I forgot to say, to correct me if maybe I did say it, but I think I forgot to say that I love the idea of the consensus in the making of constitutional soft law, and the MOU strikes me as a really interesting example of this, and one. And I hadn't realized that it includes judicial independence, which would be a very important contribution, because actually the people who are most likely to undo judicial decisions are sitting in that parliament.
Yeah.
They're politicians who can't accept the more recent run of judicial decisions, particularly in favor of religious freedom.
Mm-hmm. Yeah, and of course, this is a temporary measure or a solution, right? Before the next election, which I think will come fairly soon, because they're dishing out a lot of money, having a lot of Hari Raya or Eid open houses now, feeding people. So in thinking about that soft law, constitutional processes in constitutional soft law, I was also, again, thinking about Sri Lanka, and if this could be, at least for now, the way forward, given the tensions that has been generated in the country. I mean, I don't have answers for these questions, but it's just formed part of my thought processes for now.
So we do have a question from the audience as a follow-up to Shamshad's question, which is that if we have to choose between option A, compromising, B, constitutional deferral, in the absence of any consensus, what would be the better option? Any thoughts? It's a tough one.
Can I jump in just quickly?
Absolutely, Shamshad, go ahead.
Yeah, I have I don't know, so shall we say personal preference, but my research on Afghanistan has showed deferral or constitutional ambiguity or the design deferred will be, I think, a better option, at least during the constitutional drafting moment. It does create its problems down the line, as Don discusses in the book, how incrementalism may not be the best option. But for my work on Afghanistan has showed that deferral or constitutional ambiguity was one of the key factors that the framers chose to enable having a document. And I will give this one example in my interviews with the members of the constitutional law adjunct, at least the most important one, who could summon other representatives for their proposition. When the US and the UN and Karzai put the presidential system in front of the Constituent Assembly, if either this constitution with a powerful presidential system with the possibility to revise it down the line, 2 to 3 terms, of course, the terms for which the president Karzai could become a president, because the constitution had 2-term limits. No constitution at all, you pack and go home, because the UN and the US representatives were telling the constitutional lawyer Jirga that this decision, the haste that Don was talking about, is we have 2 or 3 days funding. If they don't manage to have an agreement in these 2 days, you don't have an agreement at all. So the most representative answer that I got from my interviews were that the reason we voted for this constitution the way we did, by standing up and praying for rain instead of any other things, because Afghanistan didn't have it was not raining a lot in 2004. So the constitution, that's how the constitution was ratified. But the reason we voted for it instead of not voting for it was because the presidential system that was drafted in the constitution was to be revisited down the line, both temporally and incidentally. And of course, by 2014, everyone inside Afghanistan, outside, knew that the presidential system does not work, but they still did not reform it. So one of the reasons was for the Taliban's reemergence, of course, was the underperformance of the Afghan government, in particularly the presidential system with a highly centralized administration. So deferral, but of course, with mechanisms to deal with it down the line.
I have a short thought, if I may, Jaclyn. I'm thinking about the example on Indonesia that I raised earlier, and just to push the conversation a bit, I think it's really context dependent. And in the case of Indonesia, there was not really a choice between, compromising or deferral. In the case of Article 29 and the religious values provision, they opted for both compromise and deferral. Compromise in the sense that there was that quid pro quo, no 7 words, but religious values. But that idea of religious values at that time was so ambiguous. In fact, they talked about it. They said that, what does religious values mean? Whose religious values? And in the end, because they were pressed for time, the MPR leadership said, okay, let's not decide this at the moment. If there is an opportunity in the future to discuss whose religious values, what are the boundaries of religious values, we'll do that at a later time. But of course, given the Indonesian Constitutional Court's decisions on that particular clause, I think it didn't serve religious freedom at the end of the day.
Right. And I think, just sort of also build upon what Shamshad said about how there are expectations that certain things will be revisited. I think if something is done under those frames, we can only think of Article 153 of the Malaysian Constitution, which was supposed to be revisited after 15 years, but no procedure was actually put in place for that revision or that revisiting, right? For that review. And I think, this is where process, becomes very important as well. How do you sort of institutionalize certain procedure to operationalize agreements that were made in order to revisit some of these initial agreements? One could be to set them out as sunset clauses, right? To say that after 15 years, they will be, it will no longer be enforced unless it is ratified once again. We are coming to the end of our time. I already pushed it by 5 minutes because we started a little bit late. But Don, you look like you have some final comments to make, so I'm happy to yield some time to you.
No, I was just going to respond to that last comment. It seems to me that where there are distributive goods involved, saying we'll revisit it later is just never going to work. And Article 153 was never going to be revisited. And as you know, of course, the privileges were expanded after 1969. So I rather doubt that having a sunset clause on the presidential system in Afghanistan would have done anything, or even in a country with a little bit more political competition. I don't think it would have had very much effect, because institutions get embedded, and the consequences of institutional development get embedded. What about all the people who are appointed by the president? And you can. I think this is just a way of gracefully bowing out of the controversy in most cases. So I'm just not certain that this is a very good answer to. If you have a problem, I think you should, look it in the eye and try to solve it. Unfortunately, Article 29 came up rather late in the proceedings, if I remember right. Isn't that right, Dian? Quite late. Well, it was after the failure of the Piagam Jakarta.
Yes, that's right.
So there wasn't much chance to to get it straight. And somebody should have said, well, here's an alternative draft. What about this? That's the only way to solve that problem, was for somebody to sit down and draft something that was more likely to be neutrally enforced than that one is. Anyway.
All right, I feel like we can go on for another hour or two, but I will not detain all of you, especially since it's very late in where Dawn and Shamshad are right now. So thank you very much to all four of you for participating in today's virtual roundtable. Thank you to our participants who obviously were very fascinated with your comments and hence had fewer questions, but I'm very sure that all of us have benefited from your insights, and so thank you very much. I think for our participants, we have a feedback slide, so thank you very much for joining us.